Good evening, everybody. So the concept of having this discussion was primarily the economic situation in Sri Lanka, as well as the economic situation around the world. As we all know, even the United States is facing a recession there, when the US Federal Reserve has indicated and raised their interest rates because they want to see that the inflation rate goes down. Even in the United Kingdom, the inflation rate has now gone up to about 13%. Interest rates have gone up by another 0.25 or something last week. So the world itself is not a happy place economically at the moment. Sri Lanka itself, as we all know, is definitely not in a happy place at the moment. So in that context, what the organizers suggested was that what is the impact in such a recessionary economy on alternate dispute resolution. And the last time this topic came up was during the 2009-9 recession, where there is conflicting information that either the ADR practice went up in some instances, but ADR practice went down in certain instances. So when I was requested to set up this panel, I thought the best people insofar as a recessionary economy and especially ADR is Dr. Kanageshwaran and Dr. Sriraj Pereira. Dr. Kanageshwaran, as we know, I think in the introduction, they said he was the architect of the SEC Act. But more importantly, in 1995, he was the architect and the main drafter of the Arbitration Act in 1995 with the Stockholm Chamber of Commerce. So we had the privilege of learning arbitration under Dr. Kanageshwaran from 1995. He is, of course, the preeminent practitioner in arbitration in Sri Lanka and needs no further introduction. And he would deal specifically with the concept of alternate dispute resolution and in the context of what we are discussing today. Dr. Pereira, on the other hand, has immense experience internationally with regard to especially investment arbitrations, and because of the time he spent as the multilateral guarantee agency of the World Bank, where he was the chief counsel for a long period of time. He is also involved at ICSID, which is the International Center for the Settlement of Investment Disputes. Those are disputes between states, state parties, and private investors in state parties. So in that context, and especially with regard to the present economic situation in Sri Lanka, his experience is invaluable because he was also involved when he was in the World Bank, when both Argentina and Venezuela went through the same problem of debt sustainability and bankruptcy. So he will speak of his experience at ICSID, where there were several claims in respect of Argentina and Venezuela, and how we can learn from that process to see whether Sri Lanka also can learn from that process to try and get out of this economic malaise that we have at the moment. So I won't take too much time. Dr. Kanageshwaran will speak first. After that, Dr. Pereira will follow. After that, we will take up a discussion from what transpires in their presentations. Dr. Kanageshwaran, over to you, please.
Thank you, Chandaka. Good evening, ladies and gentlemen. I don't want to be talking about alternate dispute resolution. You have just come out of Victor's Moot, so you probably know all about arbitration and perhaps mediation as well. I would rather dwell on the question of the results of economic downturn, recession that you're talking about. Now, as you know, economic downturn breeds disputes. So lawyers might be happy, but those practicing arbitration and mediation might be happy. So it's not totally unpleasant depending on your perspective. It breeds disputes. And the outcome of such disputes can have much greater impact upon individuals and businesses than in better time. Of course, we're going to see that. So I want to talk something about you being prepared to meet these challenges, not only what is happening now, what is likely to happen when events take a better turn and things like that. Now, litigation is a chosen avenue in Sri Lanka because we are generally known to be very litigious. But of course, for the last several decades, arbitration has come into the forefront. People appreciate the importance of that. We also have mediation, which we have now a center which deals with mediation. It's a joint venture between the Ceylon Chamber of Commerce and the ICLP. And of course, conciliation was known historically and otherwise. So all those alternate dispute resolution mechanisms are there. Therefore, when disputes are bred, you have these dispute resolution mechanisms have a crucial role to play during recession. The likelihood is that when the recession itself recedes, the numbers of claims being actively pursued will increase rather than decrease. So you need to be ready for that. What are the areas of dispute that will arise? What type of claims and disputes will be spawned by a recession? And our matter that I like to examine instead of talking about arbitration, how it works, and things like that. So advanced planning. So my emphasis this evening's talk is to address you on the necessity for advanced planning, how it can avoid disputes going forward or enable them to be handled more effectively if they do arise, as they will do, as I said, even when you take the turn and the recession takes a little better, even then disputes will not decrease, they will increase. So advanced planning can avoid disputes or enable them to be handled more effectively if they do arise, as they will. So I want to examine the type of claims that can be spawned by a recession and the type of claims that, I mean, purely from a Sri Lankan context. Dr. Pereira will talk about the international dimensions on these matters. So we made a sort of a list of things that might come up for which you must be ready. Whether you choose arbitration or mediation largely depends on the wishes of the parties. Future disputes can arise. You can, if you don't have agreements already concerning alternate dispute resolution, one can decide which course to take. So that is left to you as to what you will select and what you will not select going forward. Now, types of claims and disputes that are spawned by recession will include locally insolvencies. We are talking about many personal insolvencies. We are going to take a haircut, as the president has said a few days ago or yesterday. We are going to have problems of solvency or insolvency, bankruptcy, and related claims by administrators and liquidators in liquidation or trustees in bankruptcy, trying to recoup money for the creditors. So somebody is trying to recoup money for the creditors going after the defaulters. Banking claims. Now, we have had several issues relating to banking, arising as a result of our financial downturns, where there have been compulsory conversion of foreign exchange. If you receive into the country, you are told it has to be converted into rupees. What are the liabilities arising? They are done not with your consent, but against your consent. When the foreign money comes into your bank account on the basis of banker-customer relationship, well, it's a debtor-creditor relationship. So can they tell you, I'm sorry, old chap, I can only give it in rupees. So these things nobody have thought about it. I think these are matters you've got to be ready and can you sue the bank for your dollars, or will you get only the rupees? So banking claims. So recovery of defaulting commercial loans and realization of securities all are on the board, on the card. Property repossession. In Sri Lanka, we have that thing called parrot execution, which permits banks to go and take possession of property without going to, which are secured to it, without going into court. That's device because pushed forward by the banks long years ago. Again, the basic Roman law principles of which, if you're not a Sri Lankan, you don't need to bother about. So parrot execution, disputes concerning that, can there be the subject matter of alternate dispute resolution? Then investment disputes. On that, Dr. Berra will be expanding. We all been told. Claims against investment managers. Again, locally, it will be against investment managers not perhaps adopting appropriate risk profiles or inadequate due diligence in respect of investment. Now you can see all the haircuts coming in. So you need to have in mind area which might have to be addressed from the point of view of alternate dispute resolution. You see, consumer investment claims for mis-selling or a breach of financial services regulation. We had many litigation. We just finished arguing one some time ago, awaiting judgment on the breach of financial services legislation. Negligent investment advice are there. Insurance and reinsurance disputes, including defense of claims. Insurers in our country always find ways of avoiding liability. So can you approach it from the point of view of alternate dispute resolution? It's best litigation, as you know, proverbially, and otherwise in Sri Lanka takes a long time. So insurance, reinsurance disputes, including defense of claims against insured clients, perhaps some might be even insolvent ones. Policy coverage dispute with clients and other insurers and reinsurers. Contract dispute, mostly you probably have lots of dispute related to contracts. Whereas in good times, it may be better to do tomorrow's deal. You look over these disputes and do tomorrow's deal than to litigate over yesterday's problems. But in leaner times like now, tomorrow's deal may not be there to be done. You may not be able to do it because you don't have the money to buy it, or you don't have the services, you don't have the fuel to go around or do or deliver. And it may be commercially worthwhile or necessary to seek financial redress for the deal that has gone wrong. So contract disputes will amount to a lot. I'm looking at my time. Then claims for professional negligence are not very popular here because dog doesn't eat dog in Sri Lanka. Claims of professional negligence against accountants, financial advisors, lawyers, surveyors, overvaluation of secured properties and the like are likely to arise. So these are type of claims which might be spawned by recession. Then employment claims. Now we have Sri Lanka, much talk about restructuring, not only the country's debt, but also restructuring state-owned enterprises, which are ballooned with unnecessary employment. They want to cut down overtimes at 400% and things like that. So you want to cut down. Then you have problems related to employment actions, such as unfair selection for redundancy. And out of that also one can perhaps anticipate boardroom disputes as well. So these are some matters that have to be looked at. Tax disputes and investigations as a burden of taxation rises. We are on the threshold of a new budget. God knows what kind of new taxation will come. They have spoken about wealth tax and things like that. Raised personal income tax, corporate taxes. Then you will have problems over the tax disputes. And taxation rises and taxpayers seeking ways to reduce their liability. ways to reduce your RFI. You can arrange your RFIs in such a manner that you reduce your tax liability. Tax authority might say you are being fraudulent, etc. There is another avenue for dispute to be spawned thanks to the recession. I anticipate, hopefully not, but anticipate even matrimonial disputes. As financial pressures take their toll on personal relationship is likely to happen, perhaps not so much in Sri Lanka, but elsewhere. Then we also have problems related to trust and probate dispute, that is on the death of persons and things like that. When money is in short supply, there is an incentive to raise matters which in better times might have been left unchallenged. So these are the problems which are likely to arise and will continue to arise even after things take a turn for the better, because these will be spawned by the recession. So the purpose of telling you this dispute, the type of dispute might arise, is as a lawyer or those who are interested in alternate dispute resolution, whether not as a player in resolving the dispute, but as persons involved in the dispute wishing it to be resolved, is to plan for them. Planning for and dealing with disputes is now very important. It has always been, but now we have more so. Planning and dealing with disputes. So you must address, if it's not already done, on the dispute resolution clauses that you're going to incorporate into any problem that might arise, going forward. What sort of resolution are you looking at? Things like that, because there are a lot of new jurisprudence coming in too in the area of arbitration with regard to problems regarding negotiation prior to arbitration and things like that. So you need to be up and about and learning them and getting ready for the type of dispute resolution clauses that you might have to consider. Choice of law and jurisdiction has always been important. Not much attention is paid in our country to this kind of issues. Choice of law, what's the law they're going to apply, and the jurisdiction is going to be. Then exclusion or limitation of liability clauses. So those who are involved in resolution, in hoping to participate in the resolution of the disputes on the threshold of the problem that might arise, if they have not, if they have already arisen, still you can work on these clauses. Is to be able to address all these issues. You have to be ready for that. Exclusion clauses, limitational liability clauses going forward. Then question of insurance cover. Do you have adequate insurance covers in respect of claims? All these things are issues we looked at in respect of planning for and dealing with disputes. That I thought is an important aspect that you will have to look at, and more than the nitty-gritty of how arbitration is done and who does, what does the adjudicator do in mediation and things like that. So that ensure that you have an effective system for preserving and archiving correspondence and documents. Now, this we always note is not done. When people come to you for disputes, you find that you haven't sufficient material to be able to prove what things have actually done. Contemporary documentation is very, 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 very important. Whether it's in litigation or arbitration or mediation or whatever. So ensure that you have an effective system for preserving and archiving correspondence and documents, including now emails and electronic documents. Claims can be brought several years after the event, if not immediately. And depending documents have been lost in the meanwhile, it could damage your claim or defense. And finally, I think I've exceeded my time. Finally, I think if a dispute arises, take early legal advice. Because as you know, some rights can be lost if you delay in exercising. This, from my point of view, are important when there's a recession of the economy is in progress, because it breeds disputes. Outcome of such disputes can have a greater impact upon us and businesses than in better times. So with that, I will conclude. I trust I have addressed issues concerning you on the subject that we have been discussing today. Thank you.
Thank you, Dr. Kanageshwaran. Can I now call upon Dr. Pereira to speak about the international aspects of the subject, please?
Thank you, Mr. Jayasundara, and thank you to the organizers of the Victor's Moot Court for inviting me to make this presentation. It's a very important one. It is a very critical one. And together with such distinguished panelists, I feel very honored and humbled to address all of you on matters in Sri Lanka, particularly in the present situation. This is a complex topic because of the possible assumption, as it has been made, that an economy in recession can lead to commercial and investment disputes. This may not be necessarily so. Commercial and investment disputes can arise in any economic environment, whether in an inflationary economy, a stable economy, or a recessionary economy. It all depends on the circumstances. In fact, the present economic situation in Sri Lanka has been concluded to be very inflationary, with food and fuel inflation over 60 to 70%, very unsustainable rate of inflation. With massive printing of local currency, there cannot be any other way to describe the current economic situation other than as inflationary. However, when there have been sovereign defaults on debt, principally international sovereign bonds denominated in foreign currency, the state is beyond inflationary or recessionary. Sri Lanka, to use a very common economic term, is in sovereign bankruptcy. As it is, Sri Lanka is in the same environment as it was with Argentina in the early 2000s, Venezuela a few years later, and most recently Lebanon, in the same economic environment as Sri Lanka finds itself now. And in such circumstances, in such dire economic circumstances, investments have already been made, or investments that were already being made, and there have been foreclosures in such investments in both those countries that I mentioned before. And in Sri Lanka, the effects of the economic environment and the sovereign official declaration of sovereign default of sovereign bonds has made it now a situation in which institutional investors and other investors have already taken legal recourse and legal action in the international plane. So the pertinent question really is Sri Lanka, and I'm really relating it to Sri Lanka, and then we can relate it to circumstances of other countries that I have had experience in. Is Sri Lanka then vulnerable to disputes in these dire economic circumstances? I'm talking about sovereign bankruptcy situations. Clearly and emphatically, the answer is yes. It is precisely under these economic circumstances that it is highly likely that disputes between foreign parties against the government of Sri Lanka will arise. And I'm here trying to focus on disputes between states and governments, what is commonly known in the arbitration field as investor-state disputes. Once the economic situation is declared in a default situation, obviously they can have the circumstances can have cyclical effects. That is, that it generates a lot of disputes in almost all sectors that leads to resolution of disputes. Both formal judicial resolution and alternate dispute resolution, what we call ADR, against the government as a counterparty to investment transactions have already arisen and are more likely to arise in the near future. Already, formal judicial resolution in the form of a legal claim has been filed by the Hamilton Reserve Bank against the government of Sri Lanka in the US Southern District Court of New York for default on Sri Lanka sovereign bonds. Now, when sovereign bonds are issued by the central bank, that is a method of capitalization used by most sovereign countries in order to attract foreign currency. And these bonds are issued as against sovereign assets. And they are bought by institutional investors, both in Sri Lanka and around the world. So in the case of the Hamilton Reserve Bank, they are holders of international sovereign bonds issued by Sri Lanka, and they have been defaulted by the government for inability to have adequate foreign exchange to service bonds. Now, you know fundamentals of bond issues. They have the face value of the bond as well as the yield in time of the amounts invested in that bond, like an interest rate. In this particular case, with the Hamilton Reserve Bank, the interest rate that was to be yielded is around 5.3%, as I understand from the record. We can therefore anticipate not only filing of claims in formal judicial settings, in courts having jurisdiction, but also, of course, resort to alternate dispute resolution, ADR. So ADR is distinct from formal judicial settings in that they are alternate dispute resolution methodologies, primarily through institutional arbitration or ad hoc arbitration, depending on the arbitration agreement that has been concluded between the investors and the government as a counterparty to the investment act, to the investment agreement. So the first thing, at least theoretically, in terms of alternate dispute resolution, is the question of, not the question of, the availability of arbitration. So arbitration is, again, as I mentioned, and to repeat, has both forms, that is institutional arbitration as well as ad hoc arbitration, depending on how and what mode of resolution the investors, and in this case, again, the government party has agreed to in their investment agreements. One of the globally recognized institutional arbitration forums is the International Center for Settlement of Investment Disputes, ICSID. ICSID's creation was in 1966 under what is known as the Washington Convention. Sri Lanka is a signatory to the Washington Convention. Three well-known cases where the government of Sri Lanka was respondent all went against Sri Lanka. And now this was not in a necessarily a recessionary economy or an inflationary economy. It was due to circumstances occurring at the particular time. And the first case is a very famous one. It is called the Asian Agriculture Products Limited case, which was a Singaporean incorporated company, if I recall, that lost its investment due to a civil war situation. In fact, it was one of the first arbitrations carried out by under the aegis of ICSID. Then the next one was a case called Mihaly versus Sri Lanka, related to a possible construction of a power plant, coal-fired power plant in Sri Lanka. That was settled, went against Sri Lanka, but that was settled subsequently for an agreed amount. And the third was even more important case called the Deutsche Bank versus Sri Lanka, which related to the breach of an oil price hedging agreement in 2012 and also went against Sri Lanka. So the purpose of this is that, and as my esteemed colleague, Dr. Kanageswaran said, that we have to be prepared in the event that there are ICSID-related cases, to be prepared to defend those cases. And I'm here talking again about investor-state dispute resolution. I understand that there are several other cases that have been registered in ICSID against Sri Lanka. Very few, one or two, as I recall. But I do not know at the present moment where the progression is in those cases. But again, the point of it is that Sri Lanka is a member of or a treaty signatory to the ICSID Convention or the Washington Convention, and there could well be in this type of situation that investments in Sri Lanka may run into problems, and it might engender ICSID cases in arbitration. And as Dr. Kanageswaran pointed out very well, in the international field, it will be foreign investors who are affected by the economic situation in Sri Lanka who have encountered losses. In relation to my own experience with Argentina in the early 2000s and Venezuela subsequently, were that many investments that were made in the oil and gas sector particularly went into arbitration. Nearly 45 to 46 cases were filed with ICSID by various investors. I do not think that in Sri Lanka there is so much of investments in sectors related to oil and gas, but certainly in the manufacturing area and in the textile area, it could well be that the economic circumstances might engender breaches of contractual obligations. Very often, the cases in Argentina were based on breaches of contractual obligations by the government of Argentina at the time, and subsequently also by the government of Venezuela. And very often it was debt infusion, the debt that could not be paid, because most investments were not equity-based investments, but they were vast-scale investments capitalized both by equity as well as loans. So loans become extremely vulnerable where the loans have been made to particular investments. And sure that there are loans that are associated presently in Sri Lanka, which are really vulnerable for default by the counterparty, which is the government entity or government ministry, if you will. Then there are also the multilateral lending, which can be defaulted, loans by the Asian Development Bank, loans by the World Bank, the International Development Association of the World Bank, that are vulnerable not to be paid and may be defaulted. So settlement proceedings will become very important. It could be called mediation, but right now the settlement proceedings are taking place as a method of alternative dispute resolution. So as I said, this is already happening. If current news is being followed, default of sovereign debt has created a consortium of creditors against Sri Lanka. Principally, about 40% of the debt is related to default of international sovereign bonds. And there is already, as I said, Hamilton Reserve Bank in New York has already filed a case in judicial proceedings in the Southern District of New York. This is an alternate where a consortium of bondholders have got together and are willing to negotiate a settlement of the outstanding debt now that the defaults on sovereign debt or default of international sovereign bonds have already occurred. Now, they are being represented, as I understand, by White and Case. The government of Sri Lanka has already hired or retained Lazard Brothers, which is an financial and asset management company, a very old company, a very reputed company, incorporated in London, who have enormous experience in advising sovereign governments and other asset holders on how to resolve disputes in default situations. Essentially, what is going to happen, and this is critically important in the present economic situation, is that both the lawyers of the creditors, that is White and Case for the creditors, bondholders of Sri Lanka sovereign bonds, and Sri Lanka's own representative, that is Lazard Brothers and Clifford Chance, the lawyers, will be engaging in settlement of outstanding debt. The focus, and very important, and this is very important for young lawyers to learn, this is also something that for Sri Lankan young lawyers, as well as law students, to understand methodologies in settlement proceedings of such a nature that can be extremely complex, but in terms of the economic crisis that is occurring, there are two important postures or negotiating formats, foundations that need to be looked at carefully. From the standpoint of the lenders, it would be that they would be agreeable if the government of Sri Lanka, as the debtors, would want is, let me go back and say, the objective and the focus of the debtors, that is the government of Sri Lanka, should be to negotiate a restructuring of the bonds. And by that I mean that there would be a moratorium for a period of time, dictated on reality of the situation. Clearly, the government of Sri Lanka does not have the foreign liquidity required to service the bonds, and therefore the option would be to restructure through a moratorium, that is, give an adequate period of time so that the repayment schedule will be agreed to on the available of foreign currency. And this is really important to know, that the first is create a moratorium. Non-payment, already there is a default. So non-payment right now of the required payments at the particular time of maturity of the bonds for a period of time, so that reserves in the end can accumulate in Sri Lanka in the central bank of foreign currency, and they can be payments can be resumed at a time when these reserves, accumulated reserves, can then service the bond under a restructured agreement. The second part is also very important. Now, I said the Hamilton Reserve Bank agreement was, the original agreement was for a 5.5% interest rate. Now, one could also, as it happened in Argentina, one could also negotiate a proper lower interest rate, so that it would be very reasonable in terms of repayment. So postponement of repayments that are under the bonds, and then renegotiating a proper interest rate or a lower interest rate in order to service the bonds. This helps both sides, because the alternative is very cumbersome. And particularly in Venezuela, all the creditors agreed to a serious haircut. Nearly 40% of what was owed was forgiven, and then they went on to restructure the debt. Literally, they paid 10 cents to $4, if I can put it in that way. Argentina did the same thing, took about 40%. The Argentine creditors took about 40% haircut. What is the reason why they agreed to this? And clever negotiations can produce this result, because the alternative was for them to pursue dispute resolution formally against the government. And it means that in a situation where the government simply does not have the foreign liquidity, they will get a declaration of the amounts owed, and then they would have to pursue Sri Lankan assets that are used commercially, both in Sri Lanka. If that is not possible, then outside. For example, attachment of a Sri Lankan Airways aircraft that might land in London or in New York, and then it is impounded for purposes of relating to the award that they may, or judicial award that has been given, arbitral award or a judicial award, as the case may be, of getting relief on the debt owed. And that is a very cumbersome process, and investors do not like to proceed because it's not only cumbersome, but it is very, very costly to go to foreign jurisdictions and to attach commercial assets of a particular government. So it is critically important for two things. From the lender standpoint, they would be very willing. They would be very willing to negotiate a restructured deal in order to get at least something for what they are owed. And clever negotiations can do that. And this is really good for young lawyers to learn on the dynamics as well as the negotiating tools that are required to go into such negotiations. That we don't have counsel in Sri Lanka, and I do believe we do have counsel, but they have to rely on one of the best law firms to guide us through this. At times is regrettable, but there probably are not many options now. Government has selected both Lazard brothers and Clifford Chance. They're some of the most expensive lawyers to negotiate this deal. But in the end, if they do negotiate a very good deal for government of Sri Lanka, it would be a good thing. Now, that's the first part of it. The second part of it, as it impacts the economy. Now we are going for a rescue package, and this is what happens in sovereign default cases. It is inevitable that we have to, and I say we, but the government of Sri Lanka has to go to the International Monetary Fund for a rescue package. There is no other alternative. So that rescue package that will, in the end, be concluded it's going to be tied to this debt restructuring talks that are going on, because in the end it is about the sustainability of the debt going into the future and bringing fiscal and monetary reforms and monetary policy to a point when the economy can be stabilized. So looking forward, looking into the future, it is going to be very grim. The great sadness is that the ordinary taxpayer and the people are going to be really impoverished in the short term until these packages are concluded. So I cannot de-emphasize but the importance of this debt restructuring talks, even more so than the International Monetary Fund. They're equally important, but even more so the debt restructuring, because one of the preconditions for the International Monetary Fund proceedings is really based on successful restructuring of the outstanding debt. So the alternative to arbitration, and the arbitration is still open for investments, the alternative is one other alternate dispute resolution mechanism is what is really going on with the debt restructuring exercises that are taking place. Then, of course, formally, there is the other alternative is conciliation. Now, the 1966 Washington Convention, and I said the ICSID Convention, also have conciliation as a method by which disputes between investors and investors and states can be resolved. It has hardly ever been used. The conciliation mechanism included in the convention has been there since the time the convention has been adopted, but it has hardly been used, partly because it has been concluded to be very, very formal. One might as well as go into arbitration than go into conciliation, because it is a similar process. There has to be a conciliation commission. It could be a single conciliator that deals with it, but there is a third party involved. By the way, when I talked about bilateral settlement, there is no third party involved. It's the disputing parties that are getting together and finding a resolution for that purpose. Now, in conciliation, as I said, as it has been included as a mechanism for conciliation between the two parties, there is a conciliator or a third party involved in trying to find a conciliatory method by which the dispute can be resolved. Again, to repeat, conciliation has not been used. I think there was only one case in which, throughout the history of ICSID, only one case for conciliation. It has not been. That was brought before ICSID as a conciliation mechanism. Where that went, I'm not quite sure. But again, it has hardly been used. Now, the third method or the fourth method of alternate dispute resolution is really mediation. Mediation actually is less formal than all the others, except that in 2013, the American Arbitration Association has really included it formally in their arbitration rules in order to mediate disputes between disputing parties, not necessarily between an investor and a state, but for all purposes of commercial disputes, the mechanism of settlement is available. Now, very interestingly, and this relates, I will give you an example also of what happened with Sri Lanka in a particular situation. It's the settlement mechanism included in the MEGA countries where I work, the Multilateral Investment Guarantee Agency of the World Bank, World Bank Room that was created in 1988 through a convention in order to provide political risk insurance. But MEGA is more than a political risk insurance provider. It is also an agency that intervenes to settle ongoing disputes through the mechanism of mediation. We have been extremely successful. I said we because I'm been so associated with MEGA that even though I am retired now for more than 10 years from the institution, I have a close association with the agency. And there have been several instances in which mediation was a very successful mechanism for a couple of very important reasons. First, it is less formal. Second, it is less time consuming. Third, it is less costly. And it is mutually agreeable to think. And fourth, very importantly, while arbitration is going on, mediation also can take a parallel form between the disputing parties. And it is less formal, it is less technical, it is less based on the technical intricacies of the application of conflicting laws. So settlement has become and recognized now as a very important mechanism through which ongoing investments can also be preserved. A very, very good example was in and around 2002, I think. um, it was reported by a UK investor relating to cement consignment that they made to the Ceylon Cement Corporation, the CCC at the time, for which consignment it was not paid. It took the matter to the International Commercial Arbitration Center, and they prevailed in getting an arbitral award. They then proceeded to the Supreme Court to enforce that award. Due to some procedural problems, the case was not taken by the courts for enforcement. So what happened was that this particular investor approached MEGA and asked us whether through our Article 23b(2) of the Convention about settling disputes between investors and the states, whether they could take their case. And we, of course, agreed to, and asked the government of Sri Lanka whether they would agree to a settlement of this dispute. Indeed, the government of Sri Lanka responded very positively. In the meantime, during this process, the government of Sri Lanka had privatized the Kanka Santure, I think it was KK, as cement plant, and it was bought over by Halcyon, a cement producer of repute, also I think incorporated in UK. So all three parties came to Washington, DC, and because I had to recuse myself because of my Sri Lankan nationality, yet watched the proceedings with great interest. Both parties talked about the situation, and they agreed that the investor really had procured an award that for procedural reasons was rejected by the court, and whether they could resolve this matter. At first, the two parties were very recalcitrant, very entrenched in their positions. The Ceylon Cement Corporation, represented by the Minister of Industries, said, well, they had sold their ownership of privatized the corporation, and Halcyon had bought it over. Now, very interesting, legally speaking, when there's a successor, the successor not only succeeds to the assets, but also the liabilities of the company. And Halcyon, I must say, Halcyon Sri Lanka did acknowledge that that was the case and agreed to a certain sum for settlement, and the matter was settled. And in a similar manner, within MEGA's overall oversight, we have resolved all over the world, meaning MEGA has resolved almost all over the world many investment disputes that had come to a point where formal dispute resolution could have been engaged, and yet sought to have settlement of the dispute through amicable resolution. There's a settlement agreement, and the settlement agreement was honored, and that ended the matter in the case of Sri Lanka. And this is always what has happened in the experience of MEGA. The success rate of settlement was so high that now the International Center for Settlement of Investment Disputes, ICSID, under their convention, have made the necessary amendments also to have settlement proceedings. And settlement proceedings are without prejudice to any arbitration proceedings that might be concurrently going on the same dispute. Now, the one downside of settlement proceedings is that you cannot produce in evidence any agreements that have been reached in settlement as evidenced in the arbitration proceedings. So the without prejudice issues become very, very relevant and in terms of application. And that about completes, I think I have reached my time. That about completes my comments. I hope they have been useful. We are in for, I'm referring here to the government of Sri Lanka, in apart from the serious economic situation there, also be very vulnerable to this type of dispute that might arise in Sri Lanka. And so the lawyers, both domestic lawyers as well as foreign lawyers, should be alerted to possible situations arising. I thank you very much. I'm sorry if I exceeded my time.
Thank you, Dr. Pereira. It was most illuminating. Can I just, since we are like kind of running out of time, can I ask Dr. Kanageshwaran, sir, mediation or commercial mediation has really not caught on in Sri Lanka, even though there's an act on commercial mediation. And I understand Sri Lanka has now signed the Singapore Convention on the enforcement of international settlement agreements by mediation. What needs to be done? Because mediation, as Dr. Pereira and you both said, seems to be a better option than the more time-consuming and costly arbitration or litigation. What do you think Sri Lanka should do to increase the field of mediation in Sri Lanka?
Well, as I said, the Ceylon Chamber of Commerce and ICLP, we have a ADR center, which we have rules with regard to arbitration, new rules, and also mediation. We have also drafted a law. The draft of it has been sent, I believe, to the Ministry of Justice some time ago, which will bring into focus the importance of mediation, in that if you have a mediation and you have a decision on that, it can be enforced at law. As of now, there is no mechanism for enforcement. Mediation, we have people being trained in mediation. It's very different to arbitration, completely different. And so we have actually just last week, I think we have entered our first mediation request in Sri Lanka. So it'll be a while, but it had been made popular and people need to understand, you can't approach the lawyers' view of things in mediation. Is very, very different. I mean, I have seen it. I'm not a mediator myself, but I have looked at it and studied the subject. So it requires a lot of patience. And one man, they meet in caucuses. They mean, I don't want to go to the process of mediation, but it is, as you rightly said, gaining a lot of importance across the globe. Mediation, they seem to think it is less expensive also than arbitration. So we need to encourage that we are trying to do. The CCCP, ICLP arbitration ADR center is doing that. We need to now perhaps organize, like we did for arbitration seminars, and teach the younger people. The old lawyers, you can't teach them anything. They have already set in a particular groove of things. The younger generation, those who participate in these moots, are the ones who should be there. They are sort of virgin yet, and we'll have to fertilize them with the right approaches and attitudes. You can help in that, you younger boys.
Thank you, sir. Dr. Pereira, just to wrap up, now today's papers say that Japan, that is JICA, has pulled out from the BIA Katunayaka second phase, and they are not going to give any more money. Also today, they have said that the Central Highway project, which is funded by the Exim Bank of China, has pulled out. The funding has pulled out. Now, you spoke about multilateral negotiations, then the sovereign bond creditors negotiations. Is there a specific, and Exim is private against a state institution. Is there any alternate dispute method, resolution method, where two countries can use the ADR process to come to some agreement?
Well, there is the Permanent Court of International Arbitration in The Hague, to which again Sri Lanka is party. So that could be the state-to-state resolution there. And then there's, of course, the International Court of Justice. But the International Court of Justice, there has to be clearly a derogation from international law. So that seems to be the issue there. But certainly settlement is the option. I want to that I think is what to answer your question briefly, and then again, particularly in the Bandar Naik International Airport situation and the highway situation, the reason why they have probably withdrawn is because of the likelihood of debt, because these are debt financed. If there are aid issues, then there's no problem because there's no repayment option. But they are withdrawing simply because it's debt finance, and there is no way or any liquidity right now to service the debt. Have I answered your question?
Yes, you have. So in any restructuring, these sort of bilateral debt instruments will also have to come in at some point of time with the
correct, absolutely correct. And that's what Venezuela did. There was a lot of commercial bank lending, and then there was no, they can do it individually, but some of these lenders, they get together as a consortium, and that's what they do. For example, in Paris, of outstanding sovereign debt, they get together and then decide on resolution to debt. But here, what they did, and this is exactly what in Argentina and in Venezuela they did. They got together as a consortium, selected counsel and financial advisors, and then bilaterally, without a third party oversight or third party making a decision, they agree on the terms and conditions of restructuring. I just wanted to tell what was very interesting of the question that you asked Dr. Kanageswaran. Very often in mediation, the mediators are not lawyers or trained in law, depending on the technical situation there. They could be engineers, they could be accountants at the heart of the issue. That's the beauty of mediation, I think. Mediation and settlement, if you will. I hope I have answered.
Yes, of course, Dr. Pereira. Thank you very much, gentlemen. I'm sorry I could have continued having this discussion for much longer, but we are on a tight schedule, and I think the organizers have been doing this for the last 2 days. So let me thank both Dr. Kanageswaran and Dr. Pereira, who I think is in the morning in the US, and Dr. Kanageswaran in the late night in Colombo, for giving up your time on this topic. And I would also like to thank the organizers for giving us this opportunity to bring some aspect of ADR and the economy to the notice of the participants. Thank you.
Thank you very much for having us.